Let's continue with my video series on judgments. This is part 2 and we're going to be talking about judgment upon agreement and judgment on the pleadings. Judgment upon agreed statement of facts are also known as judgment upon agreement of the parties. This is found in Rule 30 of Section 7. The section provides that the parties may come to a written agreement on certain facts or all of the facts of the case and agree to submit the case for decision. So it's that simple. This is one way in which the parties can facilitate the proceedings by agreeing on the facts, thereby dispensing with the need to present evidence, and the judge will now render a decision on the case. Alright, let's go to the next one, which is the bulk of this video, and that is judgment on the pleadings. This is provided for in Rule 34 of the Rules of Court. And there are two grounds for judgment on the pleadings. The first is when the answer fails to tender an issue, or number 2, when it otherwise admits the material allegations of the adverse party's pleading. There must be a motion filed by the claiming party. When we say claiming party, we generally refer to the plaintiff. However, the claiming party may also be the defendant when we talk about his counterclaim. Now, the response of the court when any of these two grounds are present is either to motu proprio order that there will be a judgment on the pleadings or to await the filing of a motion by the claiming party. If a motion is filed, Rule 15 will have to apply. What is Rule 15? Rule 15 is about motions. And a motion for judgment on the pleadings is what we call a litigious motion. In that case, there are certain requirements that the movant must comply with. He must submit the motion in writing, and then he must serve a copy upon the adverse party before filing it in court. The adverse party will have 5 days to file a written opposition, and the court will have to render a resolution within 15 days. Now, there are 7 kinds of pleadings for purposes of applying this rule on judgment on the pleadings, and I would like to emphasize this. So by way of review, the 7 kinds of pleadings are the complaint, the answer, reply, counterclaim, cross-claim, third-party complaint, fourth-party complaint, etc., and complaint in intervention. Why am I emphasizing this? Because in law practice, we have a tendency to refer to everything that is in the case files other than the court order or decision as pleadings. So sometimes we talk about, we refer to the motions and manifestations and memoranda as pleadings. But strictly speaking, under the rules of court, when we say pleadings, we are only referring to these 7 pleadings. And therefore, again, for purposes of applying the rules on judgment on the pleadings, we are only referring to these pleadings. Now, the answer of the defendant must show one of 2 things, either that it fails to tender an issue or it admits the material allegations of the pleadings of the adverse party. So, Mongao versus Price Properties Corporation, a 2005 case, tells us when does a party, when does an answer fail to tender an issue, or when does the party admit the material allegations of the other party's pleadings. According to the Supreme Court, the answer would fail to tender an issue if it does not comply with the requirements for a specific denial set out in Section 10 or Section 8 of Rule 8, and it would admit the material allegations of the adverse party's pleadings not only where it expressly confesses the truthfulness thereof, but also if it omits to deal with them at all. So some important points about this. Let's go back to that slide that says the answer does not comply with the requirements for a specific denial as set out or set forth in the rules. When we make a specific denial in our answer, we can make a direct denial. For example, the complaint alleges that the defendant borrowed a sum of money from the plaintiff on a given date. Let's say that is found in paragraph 5 of the complaint. The defendant can make a specific denial by stating the defendant denies the allegations in such paragraph of the complaint, the truth being that he never borrowed any sum of money from the plaintiff at any point in time, period. So the clause, the truth being that, with an explanation of what really happened, is the key to making a proper specific denial. If that clause is omitted, even if the answer says that he is specifically denying a certain allegation of the complaint, that will amount to an admission. All right? So, and then there's another technical requirement, and that is when the complaint is hinged on an actionable document such as a promissory note. Let us say that the defendant would like to deny the genuineness and due execution of the promissory note. His answer must be under oath. His answer, if it is not placed under oath, will be deemed to have admitted the genuineness and due execution of the promissory note, even if he says he is specifically denying it. So that is a technical requirement that must be observed by the defendant. Now, the case of Asian Construction and Development Corporation versus Sanadel is a good illustration of a case when a judgment on the pleadings was properly rendered. This case involves a complaint for a sum of money filed by Sanadel Company against Asian Construction, or otherwise known as Asia Construct. And they reduced their transaction into a memorandum of agreement. In the course of their business relationship, payments were made, but there was an outstanding obligation of $615,000 US dollars. Asia Construct did not pay, so Sanadel sent a demand letter for payment. And despite receipt, Asia Construct still did not pay, compelling Sanadel to file a complaint for a sum of money. The defendant, Asia Construct, raised three defenses in its answer. Number one, the certification against non-forum shopping was erroneous. Number two, that the plaintiff, being a foreign entity, has no legal capacity to sue. And number three, that it could not pay its obligation because of a fortuitous event. But note that nowhere in its answer did it ever deny the genuineness and due execution of the memorandum of agreement, nor did it deny the existence of the plaintiff's claim. The plaintiff moved for judgment on the pleadings. The RTC ruled in plaintiff's favor, and this ruling was upheld by the Court of Appeals. So Asia Construct brought the issue before the Supreme Court, and the sole question was whether or not judgment on the pleadings is proper. The Supreme Court said, yes, judgment on the pleadings is proper in this case because there was no specific denial and there was no issue concerning the claims raised by the plaintiff. Now remember, there are three cases in which judgment on the pleadings cannot apply, and you must already know this because when we talk about marriage, we know the philosophy of sanctity of marriage that is espoused or undergirding Philippine laws. And therefore, these three cases concerning marriage can never be the subject of a judgment on the pleadings. Number one, a proceeding for declaration of nullity of marriage. Number two, an action for annulment of marriage. And number three, proceedings for legal separation. So that's it for judgment upon agreement and judgment on the pleadings. Let us have a little self-check to find out if you will remember the things that we have discussed in this video. What are the three requisites for a judgment upon agreed statement of facts? Number one, it must be in writing. Two, the parties must agree upon some or all of the facts. And three, the parties must agree to submit the case for resolution without evidence. What are the grounds for filing a motion for judgment on the pleadings? The answer fails to tender an issue, or the answer admits the material allegations of the adverse party's pleading. True or false? Either party may file a motion for judgment on the pleadings. False. Only the claiming party, such as the plaintiff or defendant on a counterclaim, may file a motion for judgment on the pleadings. What are the three cases in which a party can never move for judgment on the pleadings? Declaration of nullity of marriage, annulment of marriage, and legal separation. Alright, so that's all for now, and I will be seeing you next time.